Sorry to have kept you waiting, but we thought you should see anyway, you should see a copy of this authority, which we thought might be relevant to this hearing. So that's been the cause of the delay. Yes, Mr. Amos.
Lord, indeed. Thank you. And may it please the court, I appear in this matter together with my learned junior, Mr. Grant Lazarus, on behalf of the appellant husband, Mr. Luca Manetta, who, as the court, I believe, has been informed, is in enforced quarantine in Turin, having attempted to travel to today's hearing and having tested positive, although asymptomatic. So I am very sorry that he, Mr. Manetta, is not here in person.
Is he able to watch on live stream?
He is able to watch on live stream.
Good.
And he is keenly following the proceedings, as my lord may well anticipate. But for the respondent wife, Dr. De Filippo, she is represented today by my learned friend, Mr. Stuart McGee. And as your lordships will appreciate, although Dr. De Filippo is the respondent to this appeal, she was, of course, the petitioner in the English petition for divorce. And it is that petition which is very much at the centre of this appeal. Because
just for the record, Mr. Amos, as you will presumably know this, I'm familiar with the parties in this case.
my lord, indeed so, and we sent through, but I collect it didn't arrive yesterday evening, the judgment which your lordship delivered.
Well, I've printed it off for my own benefit. I don't think it's directly relevant to today's.
Well, my lord, with respect, I entirely agree with your lordship, but certainly we became aware as soon as we saw the list for today that there was that previous connection that your lordship had with the case, and for that reason, my learned junior emailed to the court the judgment that your lordship, my lord, Lord Justice Baker, gave in November 2018.
Yes.
At that stage, also in relation to jurisdiction, but only in relation to child maintenance and Tolata. And therefore, with respect, I entirely agree with your lordship's observation that beyond your lordship having a background knowledge, which clearly 3 years ago was very detailed indeed, but beyond that, it has no further relevance in our submission.
Save to illustrate that these parties have been arguing about jurisdiction and all sorts of matters for years, Mr. Amos. And it's very dispiriting to find that the whole question of the resolution of their unhappy relationship has not yet been finalised.
My lord, with respect, that cannot be gainsaid, and I would not seek to...
Not to mention, if I may add, it's not to mention the time that it has taken up in the courts of this country and Italy to get this far, where there's the hard-pressed resources, family and civil resources of both countries.
Again, my lord, with respect, I would not challenge that proposition as a matter of generality, or indeed relative to this case, but it does not, in my submission, detract from the force of the proposition which the husband advances and invites this court to accept, that if, as we say, Article 19.3 required mandatorily the English court in the person of Her Honour Judge Roberts in November and December of 2020 to dismiss the English petition, then that as a matter of law, and indeed upholding the rule of law, is unaffected and undiminished by the passage of time and the proliferation of arguments on both sides between these two parties, one against the other.
That, speaking for myself, to my ear, sounds a slightly different formulation of your case from that set out in the skeleton. Because as I understood the skeleton, it was that the petition should have been dismissed some time ago, not that it should have been dismissed by Her Honour Judge Roberts. Your submission is that it, Her Honour Judge, when the case was before her, she was required by Article 19 to dismiss the petition. Is that right?
My Lord, yes, it is.
Right, okay.
And I am very conscious, of course, that the husband has been given permission only to appeal in relation to ground one.
Yes.
And I will be seeking to persuade your lordships that that is indeed the ground that is, as we say, rightly made out on this appeal. And again, with respect, it endorses in my submission the observation already made by my Lord Justice Baker that the previous involvement that my Lord Justice Baker had in the case now 3 years ago is not actually relevant to today's hearing, precisely because one is dealing with a matter of law, Article 19.3.
Yeah.
And it's for that reason also, if I may say this by way of preliminary, that whilst we are, I'm sure I speak for all of us, extremely grateful to my Lord Justice Moylan for supplying the Liberato case, in my submission at any rate, it does not change the outcome for this case, for the reasons that I will develop.
Right.
But nevertheless, so that the court knows the direction at any rate of my travel. I hope that is.
So it's a pure issue. We obviously read the papers, but as a pure issue of law, really what we need to look at is Article 19 in the authorities.
My Lord, yes. And
there isn't any. We know the chronology.
yes.
Is there anything you want to add to the chronology?
My Lord, no, except to draw the court's attention, if I may, and I'll come back to it, to that passage in the wife's own chronology, and I hope that the parties will forgive me and the court will allow the usual reference to husband and wife. I mean no disrespect, obviously, to either. But as a shorthand,
yes,
the reference to the wife's own chronology in the supplemental bundle that the court has, and forgive me, I'm assuming that I'm giving paper references
yes,
throughout, so
yes.
I will do that unless otherwise instructed, and it is, forgive me just a moment, it is at page 37 in the paper version of the supplemental bundle. And that is a document headed chronology prepared by applicant. And as my lords will know already, this is a case where the wife has acted substantially in person throughout, but substantially in parallel throughout with direct access counsel. Formerly Miss Sally Jackson, and now, as your lordships know, Mr. McGee.
yes.
And this document, prepared by the wife, entitled Chronology Prepared by the Applicant, that is the wife, is dated the 21st of June of 2016. and I anticipate fully underlining the point that has just fallen from my Lord Justice Baker, that this has been going on a very long time. But in any event, as at June 2016, the wife was saying...
Sorry, you say this was prepared in June 2016?
Lord, yes.
It can't be right, because it's referring to events in 2017.
I'm very sorry. Forgive me.
And it's my copy on page 40 is dated
June
2017.
I'm sorry, absolutely right, and I'm grateful to my Lord Justice Coulson.
Even that's... Yes, okay, that's it. So it's June 17.
It's dated June 17.
Yeah,
I'm sorry I said
no,
16. But I do emphasise
So what do you
the
want
point
us to look
that
at?
it's dated 2017.
Yes.
And the point at E37, please, is in the first paragraph and in the line 6 lines up from the end of the paragraph. There is a sentence that starts just into the line, due to the complexity of the situation, I decided to change lawyer and instructed Stala Jarambulus at Silverman Sherika. We organised 2 meetings with experts of international law, and then it's this next sentence. We decided to present the divorce knowing that it could have been put on stay as it happened and where it is now. So that is the wife's own assertion that as at the time the English petition was issued, it's common ground that it was second in time to proceedings which were live and in straight competition and straight priority, namely the Italian judicial separation proceedings.
I thought there was a dispute for some period in respect of the Italian court's jurisdiction, and that was only resolved at some date that I can't remember. There was certainly an initial challenge to the Italian court's jurisdiction.
My Lord,
Had that been resolved by June 16?
well, my Lord, we would say it was resolved in May 17, and of course, as I was rightly corrected by my Lord Justice Coulson, this document is June 17.
At the hearing in Turin,
Yes, 18th May 2017.
when Mr. Carla, although he challenged the interpretation of the order,
Yes.
was taken to have conceded jurisdiction.
Correct, and that is recorded on the Italian documents, and thereafter was not in serious
Right.
dispute. But in any event, I do rely on the...
There's been no oral evidence, there's been no cross-examination of the parties. It was decided simply as a matter of law.
Correct. That indeed is also my understanding.
Yes.
But from today's perspective, in the context of what the wife herself was asserting to the English court as at June 2017, again,
Yes.
2017,
Yep.
not 16, I apologise. And so, in those circumstances, and coming back to my Lord Justice Moylan's question to me about the scope of the ground, the one,
Yes.
it is, of course, permission to appeal limited to that ground, and that is in accordance with the order of Mr. Justice Peel,
Yes.
which your lordships have in the core bundle at page 70.
Yes.
That is the order of the 2nd of February
Yes.
of this year, 2021. And the court will see reference at the top of that page 70 to the order of Her Honour Judge Roberts dated the 16th of December 2020. There has been some confusion, no fault that matters anywhere, but some confusion as to dates. and the court will no doubt already have clear that the judgment itself, the written judgment issued by Her Honour Judge Roberts herself in email, in writing, is dated the 16th of December 2020. Yes. That's at Core Bundle, page 44. Yes. The order that gave effect to that judgment is in fact dated the 22nd of January 2021. Yes. Nothing turns on those differences, but the order itself is at page 41 of the Core Bundle, dated 22nd of January 2021, giving effect to the judgment at page 44 of the Core Bundle from the previous month of December, indeed exactly 1 year ago from today. And it is that order of the 22nd of January 2021 that is the subject of this appeal, although clearly I will be taking the court to the learned judge's judgment in that regard. But the order of Mr. Justice Peel, therefore, at page 70 of the Core Bundle, gives to the husband permission to appeal in respect of ground 1, and in giving the reasons...
Roman 6 is the key point.
My Lord, indeed.
Yeah.
And it is the point that the learned judge considered that she should not entertain the husband's application to dismiss the English petition pursuant to Article 19.3 because it was too late to do so, and no formal application had been made by the husband, although it had been raised orally at an earlier stage during the proceedings. And then Mr. Justice Peel went on to say it is arguable that the judge did have the power to make an Article 19.3 order, particularly given the mandatory language of Article 19.3, which appears to dispense with any discretionary element, and if so, should have considered whether to make such an order. And we do say, with respect, that that is, as my Lord Justice Baker expressed a moment ago, the key point in the case. And we do say that that is the foundation of ground 1 in the grounds of appeal.
And it should have been dismissed on what basis?
It should have been dismissed, my Lord, on the basis that at all material times up to the 7th of October 2019, the English petition...
7th of October, did you say?
7th of October. I take that because that's the date that Her Honour Judge Roberts took. There was an argument as to whether it was the 9th, and for present purposes, with respect, doesn't matter.
I'm sorry I interrupted you. At all material times up to the 7th of October, yes?
There were competitive, use that word neutrally, competitive prior Italian proceedings that, in accordance with Article 19.3, mandatorily required the English court actively to dismiss the English proceedings. The wording of Article 19.3 is to decline jurisdiction. So the strict wording requirement is that the English court was required to decline jurisdiction.
What do you mean by the use of the word actively?
Well, my Lord, I'm taking it, if I may, from your Lordship's own words, I hope, accurately, but we'll see that in a moment.
Shaky ground, if you ask me.
In the case of E against E,
right,
which, as your Lordship may anticipate, I rely on quite heavily.
Right.
But I appreciate that we're going to need to look at that.
Yes. Okay, but that's that.
The proposition is that the English court was required actively to dismiss, as I will invite this court to find is the proposition advanced by my Lord Justice Moylan at first instance, as he then was in the case of E against E. And that not having been done, it did not end the obligation.
So you mean not having, the fact that the proceedings were not dismissed prior to the 7th of October 2019, and as at that date became the only extant divorce judicial separation proceedings? Do you accept that?
That is the finding of Her Honour Judge Roberts, and we
Yes.
have not been given
No.
permission
Permission
to
to
appeal
challenge
that.
that.
So,
So-
whilst I might otherwise have quite a lot to say about it, I'm not going to
No.
trespass upon this court's patience today.
Yes.
Yeah.
So it's the
And unless invited to do so, of course, but
No.
I don't anticipate that.
So you're saying that the fact that the proceedings weren't dismissed prior to the 7th of October, and as a result of that were the only extant proceedings as at the 7th of October and since then, does not have the consequence that the court should not dismiss the proceedings on the basis
Correct.
that prior to that they were second in time.
My Lord, exactly so with respect. If I can put it in the vernacular, two wrongs do not make a right. The English court had been in error throughout up to the 7th of October 2019 in not actively dismissing the English petition. Having been in that error throughout, it cannot be right in my submission then to say, well, by a negative chance in the sense that the Italian proceedings have now as Her Honour Judge Roberts find, have come to an end. Therefore, there is no longer a competitive set of proceedings.
Okay, you're not arguing, are you, that the proceedings, English proceedings, were dismissed or whatever phrase as a matter operation of law? There had to be a positive act by the court dismissing or declining jurisdiction. It's not
Correct.
The regulation doesn't apply by operation of law.
I cannot point you to an automatic.
Well, there's no authority in either.
Exactly.
So far I've been able to find either under Article 19 or in the equivalent provisions of Brussels 1 Lugano. You accept that? It's not operation of law.
I do. But
So
as
something positive has to be done by the English court.
yes, but
Actively has to be done.
actively, to adopt my Lord Justice Moylan's word, and I'm
I'm
very
first-
conscious.
at first
I'm looking forward to seeing.
I'm very conscious that I am still going to have to produce, rabbit-like or otherwise, the word. But nevertheless,
Yes.
something has to be done actively.
Yes.
And with respect to my Lord Justice Baker's comment, I am not submitting that there is an automatic operation of law, but as a very close fallback, I am submitting that the English court cannot say, oh, well, and again, forgive the vernacular, but whoops, we forgot to do that, we were asleep, we didn't notice it, and therefore, lo and behold, the petition that we should have dismissed throughout what was really quite a long period of time and a number of invitations suddenly acquires priority status.
On what basis was the application for dismissal made? Where do we find that?
My Lord, in a large number of places, if I can put it that way, I'm going to take the court to them, but to short circuit your Lordship's question, if the question is, show us a piece of paper, I cannot do that. I cannot show you
No, I know no formal application was
a
made.
formal application.
But you're saying the court should have done something, which actually you're saying the court was asked to do.
Yes.
Not formally, but by informal application
Yes.
through the course of hearings. And I just wanted to see the basis on which that was, those applications were made.
Can I take your Lordships, if it's a convenient moment, to answer that immediately?
Yes.
Therefore, to the supplemental bundle and to page 314.
So these are closing submissions
Exactly.
before Judge Roberts?
Exactly. I'm deliberately going to take it from the back,
Yes.
going back earlier in time, to demonstrate that it was or should have been absolutely centre of Her Honour Judge Roberts' consideration, and indeed is mentioned in the judgment, as your lordships will have seen, but she says, I can treat this very briefly.
So this says that the petition should have been dismissed in 2016.
Yes, and as your lordship see, paragraph 4, whilst it's recognised that this initial submission is one which may not be welcomed, it is nevertheless one which must be repeated. And going back a page, your lordships will see the quote coming up, the reference to E&E, which is my Lord Justice Moylan's case at first instance, and I will come back to that if I may.
Sorry, going back a page.
But going back a page, therefore 316.
Oh, sorry. Wait a minute, I was on
Yes, I'm
315
sorry, I am mixing up paper and electronic. I apologise in advance because I may be doing this more than once. I've just done it and I'm sorry.
We were on page 314, paragraph 4. Is that right?
Correct. We were on 314, paper 314,
Yes.
paragraph 4, and that is where I said that there is also coming up the reference to your lordships, my Lord Justice Moylan's case at first instance of E against E.
So this, again, if just focusing on paragraph 4 for a minute,
Yes.
it's, the petition should be dismissed because the Central Family Court had no option but to dismiss it in 2016. So that is should have been dismissed in 2016, wasn't, but should still nevertheless now be dismissed.
My Lord, yes.
And that's why I was saying that I thought the way you formulated it now was slightly different from the way it had been formulated previously, which was that something should have happened which didn't happen, and the court should now do what it should have done but didn't.
That is, with respect, I would suggest the flip side of my vernacular, two wrongs don't make a right.
I'm just trying to identify the basis of the application that was made, and this is the court had no option to dismiss but to dismiss the petition. Now, this is one of the problems with it being just in in written submissions in 2016. So it is saying something that should have happened didn't happen.
My Lord, yes, and I shall seek to persuade your lordships that the number and variety of the occasions on which the dismissal point was made means that it should have not only had a more central consideration in the judgment of Her Honour Judge Roberts, but also should have led to her acceding to the reminder and invitation to dismiss.
But just so we're absolutely clear about this, you're saying should have, but the fact is it wasn't. Is that right? It wasn't dismissed at any point before Judge Roberts'
Correct.
hearing. Okay. And are you going to take us back to the other side, end of the telescope and look at the...
I am.
Because obviously the first thing is to look at the petition and then at the answer or acknowledgement of service. Do we have that?
Well, I think...
The document in which the respondent is required or invited to address the question of jurisdiction.
Yeah,
The petition will say on what basis, why does the court have jurisdiction? And the respondent will have to respond, the opportunity to respond to that, I think, in the acknowledgement of service. I'm being hesitant here because all this is now online, of course.
My Lord, yes, but nevertheless, with respect, so far I, with respect, agree with your Lordship's analysis, and the answer to the question, do we have it here in the bundle, is regrettably no.
But that, okay, so that's, is it the, I ought to have looked this up, but is it there was an acknowledgement of service before the answers?
Correct.
Any answers
Petition,
filed?
acknowledgement of service, answer.
And is it in the acknowledgement of service that the respondent is invited to address the question of jurisdiction first? I think it is, but I'll.
Yes, but it's invited in the context of where are you habitually resident, domiciled, and of what citizenship, and thereafter do you accept the basis of the petition. So,
and this illustrates what's quite important here. The English court had jurisdiction. Both courts had jurisdiction under their own jurisdictional rules.
yes,
And continued to have jurisdiction until one of the court declines it.
well, my Lord,
Do you agree with that proposition?
in my submission, no, because, and this is with respect to the rule of law point, the European law, and as we all accept, this is a pre-Brexit case, and so when I'm talking about European law, it's with that postscript caveat. But the rule of law point is that European law mandatorily required the English court to actively dismiss the petition.
But until it did so, the petition remained, the court continued to have jurisdiction.
Well, with respect, I would...
Or have we got to the kernel of the argument?
I would respectfully challenge that.
Okay, that's the point.
Observation.
Yeah, okay.
Because the matter of seisin and priority is very clearly set out between Article 16 and Article 19. And unless one is going to say that the English court has some margin of error rather than margin of appreciation, but margin of error in implementing Article 19.3, then in my submission, the legal position is very clear that the focus shifts to Italy and England must dismiss.
Okay, but the scheme is this: isn't it? Both when the proceedings are, when the court is first seized, both courts had jurisdiction.
Yes, under their own law.
Under their own
Under
laws.
the regulation.
Under the regulations, yeah. And the proceedings, both courts retain jurisdiction until the jurisdiction of the first seized court is quotes established. At which point, the English court is under the regulation required to decline.
Correct, with respect.
But until it declines, it retains jurisdiction.
Well, my Lord, one could, of course, advance arguments as to the status by analogy with nullity arguments or voidability arguments of the second in time proceedings, which were the English divorce proceedings, where, in breach of Article 19.3, the English court fails to do that which is mandated to do. Learned friend Mr. McGee, in his skeleton, talks about the court being entitled to apply Article 19.3, and with respect, not surprisingly, we say, no, mandated.
All right, well, we're going, it's my fault, we're sort of rather doing a preliminary tour of the arguments.
Well, Lord, if I may say so, it's helpful, certainly from my perspective, in opening those arguments to the court in this way. So I positively invite or encourage, insofar as I may, that approach.
But so far you've taken us to paragraph 4, and you said you were going in reverse chronology. So
Yes.
do you want to take us to the
Yes,
next one?
I'm sorry. Then if you would turn back, and we're still therefore in the final submissions,
Yes,
and if I could invite the court's attention to the previous page, which is paper 313.
yes,
These are the closing written submissions on behalf of Mr. Manetta, the husband to Her Honour Judge Roberts. The petition should be dismissed, 3-1, at
yes.
paper
Yes.
313. And this was a recurring theme.
Yes.
If,
I would again draw attention to the word was. The CFC was obliged to dismiss the petition. That's just an observation. You don't need to comment. Yes.
Thank you, Lord. The previous reference, and if it assists the court to go in the opposite direction, of course, please do say so.
No, no,
But turning to paper 283, you have the conclusions of the husband's skeleton argument for that hearing in front of Her Honour Judge Roberts.
yes.
And I'm going to come back in a moment, if I may, to what I will refer to as the natural sympathy factor for...
Sorry, can we first of all just
Yes.
show, you're drawing our attention, I'm looking at paragraph 60A, declared that the Court of Turin remains first seized. So it was put on the basis there that the Turin Court remained first seized.
Yes, but 60C dismiss the wife's English petition.
No, I understand that what I'm trying to identify by going through this with you now is to see the basis on which it was being argued that the petition should be dismissed. And here we see that it was on the basis that the Court of Turin remains first seized.
And my lord will appreciate that the husband's case as advanced to Her Honour Judge Roberts was on a number of separate aspects, most of which, it's fair to say, are covered by grounds 2 to 9 of the appeal for which
Yes.
there is no petition,
Yes.
no permission. But staying with this same...
See, we're having to do this because no formal application was made and there's no reference to any acknowledgement of service in the papers. The first order refers to correspondence, it doesn't refer to acknowledgement of service. So what we're trying to do is identify, if there had been an application, what would it have said?
My lord, yes, and as I accept, there is no piece
Yes.
of paper that I can point to.
Okay, so what's the next formulation?
Back, please, to paper 278. And again, this is the skeleton argument of the husband for trial in front of Her Honour Judge Roberts.
Yes,
Paragraph 36 at the top of the page, paper
Yes.
278. Under the heading, issues addressed, and then the requirement to dismiss W's petition by the court second seized. H's invitation to the court in August 2019 to dismiss W's petition was repeated on 12th of May, but was never addressed. Please see again the reference to paragraph 42 from E&E, that's your lordship, my Lord Justice Moylan's case, and the reference therein to Re G, and Re G is the Lady Justice Black as she then was in the Court of Appeal dealing with Article 19. And that is consonant with E&E in terms of the actively dismissing. That is the meaning of declining jurisdiction. And so, again, we say, with respect, that this was squarely before Her Honour Judge Roberts. And similarly, in this same document, going back to paper 276, paragraph 35A, your lordship see the risk of repetition reference, but the requirement within Article 19.3 that the court second seized shall decline jurisdiction by dismissing.
Yes.
Lord, if I can take you back then to the quote from E&E. It is paper 268. And again, husband's skeleton argument. At the top of the page, paper 268, your lordships see the quote from Article 19.3. It's hanging over from paragraph 13 that starts on the previous page with the words Article 19.3 of Brussels 2A provides.
Yes.
It quotes it as where the jurisdiction of the court first seized, that's the Italian court, in the judicial separation proceedings, is established. The second court seized shall decline jurisdiction in favour of that court. And so, coming back to my Lord Justice Baker's question about, well, weren't both courts seized, both courts with jurisdiction, until dismissed? That is with respect why I would not accept the proposition that beyond the point at which Article 19.3 required the English court to dismiss its proceedings, it remained seized under the regulation Brussels 2A, or 2 revised. And it's where...
Sorry, can I make a note of that? Because that's obviously the key point in the appeal. Beyond the point that Article 19 required
the English court to dismiss its petition.
Beyond that point?
Yes.
You say no jurisdiction?
Correct, my lord.
And your
So
authority...
jurisdiction up, sorry. So
Sorry, no,
jurisdiction up to then, but at that point, you say the jurisdiction came to an end?
My lord, yes.
And where do you say, what precise authority are you relying on for that proposition?
Well, my lord, I'm going to take the court, if I may, to
fine.
E&E.
Okay, fine.
But so this is sorry to come across. This is by operation of law. In other words, by operation of Article 19.3.
Yes.
Whatever the English court actually does, the English court, A, no longer has jurisdiction, and B, is no longer seized. Was that your submission?
My lord, no longer seized in the context of Articles 16 and 19 that set up an iron priority.
No, well, you either are seized or aren't seized. So your submission is that the beyond, when the court, the jurisdiction of the first court has been established, the effect is that the second court, whatever it actually does, no longer has jurisdiction and is no longer seized.
My lord, yes. And I take that with respect from your lordship's case of E&E. The
Don't worry. Sorry. Don't just. Can we go through the
yes,
the points and then go to the authorities? Sorry for that, because
Not at
I
all.
just want to get to the end of this particular part of your submissions, identifying how the case was formulated below. But that is extremely helpful to encapsulate your case in that submission. So thank you.
No jurisdiction and the court no longer seized. Once, at the point the Article 19 required the English court to dismiss the petition, there was no English court no longer had jurisdiction and was no longer seized. That's your proposition.
my lord, yes. Because, with respect, to do otherwise is by definition to ignore the mandatory effect of 19.3. And that comes back to what I'm going to refer to as a negative chance. That if I have failed as the English court to apply Article 19.3 as I should have done, and then at a later stage, on Her Honour Judge Roberts' findings, the other proceedings come to an end, however briefly, for present purposes, doesn't matter. If those other proceedings come to an end, it cannot be right in my submission for the English court then to be able to say, well, because I failed to do that which I was mandated to do, now, magically or otherwise, the English proceedings are still in existence and are therefore first in time.
So just to be clear, what Judge Roberts ought to do, Judge Roberts ought to dismiss the petition, you said, because the court no longer had jurisdiction. Full stop.
Correct. With respect, yes.
And there were a nullity after that, because if the court doesn't have jurisdiction, is no longer seized, they're effectively a nullity.
Well,
They don't
yes.
exist, which is why liberato might be relevant. Just so you know where my mind is going.
And
Right.
A and B too.
But again, can we go back to your chronology?
A and B, the
Supreme
French
Court.
judicial
Yeah.
separation case.
Anyway,
We're running ahead. Can we just go back? I know. I don't. It's just.
Now, I've positively invited it, so I am,
No,
of course, not
I
making
think
any
we
complaints.
invited it too.
Don't look at me. I'm sitting here quietly.
I was looking at the clock. Actually.
my
Can
lord,
we go back to? Can we complete this part? Sorry, we keep taking you off that course, Mr. Amos.
Yes,
Right.
I was inviting my lords to look at supplemental bundle paper 268, which is the skeleton argument for the husband for the trial in front of Her Honour Judge Roberts.
Yes.
And paragraph 14.
Right. Okay. We read that. That's the quote from E&E. Yes.
So that is the kernel of my submission that it's active dismissal required by Article 19.3.
Okay. Are you taking us to any other passages in the submissions that set out the case that was being advanced?
My lord,
That is. I'm not saying you have to. I'm just saying if there is anything else that you want to draw attention to, then please do.
yes. The next reference going back is to paper 246. However, it is important in that context.
Sorry, can we just... These are submissions dated 11th of May, yes?
And so I was going to say it's important in that context to say that these are submissions made prior to and not to
Yes.
Her Honour Judge Roberts. And
Yes.
for that reason, I'm assuming that this court is going to say, well, we're not very interested in what was said to any previous court. What we're interested in is what was said to Her Honour Judge Roberts and why you, the appellant, say that she dealt with those submissions wrongly.
Well, for
Okay.
my part, I am quite interested in just clarifying. This is submission to Judge Everett. Aren't we?
My lord, yes.
And inviting him. Were you inviting him, or were your predecessors inviting him to dismiss the petition?
My learned junior, who is present in court,
He
Mr.
was.
Lazarus,
Mr.
was...
Lazarus was inviting him to dismiss the petition,
Yes.
and he didn't.
Well,
And the basis of it is what, paragraph 50?
my lord, forgive me if I can answer Lord Justice
Sorry.
Baker's
Yes.
point first, because it's an important point. He did not, this is His Honour Judge Everall, did not decline, did not refuse to dismiss, and I can take your lordships to all of the references. He did not accede to the request and actually implement it, nor did he make any order about it. And the transcript of the relevant hearing, sadly, but you may think predictably, has not been lost. It was that there was something technologically insufficient, and therefore it was impossible to create a word transcript. So we do not have that record. And as your lordships will have seen from Her Honour Judge Roberts's judgment, there were a number of separate and cumulative difficulties that faced Her Honour Judge Roberts, including the inadequate time estimate, and including the fact that, as she observed, a hearing in front of His Honour Judge Everell that had spanned over 5 days had not dealt with the, and I put this as neutrally as Her Honour Judge Roberts put it as well, had not dealt with the logically primary issue.
Right, thank you. So if we look at paragraph 50, this is the basis on which the application, informal application, was being made for dismissal. And it was that the husband's case was that the Italian courts remained seized of Brussels 2A proceedings.
Correct.
So such that the notion of the Italian courts ceasing to be seized is artificial. That was how the case was being
Correct.
run.
And it's right to say, of course, that Her Honour Judge Roberts' finding was that, no, that's incorrect because they came to an
Yes.
end, and I haven't got permission to argue against that.
Yes, yes.
As I said earlier, I would otherwise have quite a lot to say about it, but I'm clearly not
No.
in a position to do so. But it doesn't, with respect, change, well, forgive me, it may change it, it doesn't disable the submission. That whether or not, as at the time of the hearing in front of Her Honour Judge Roberts in November 2020, whether or not at that time Italian prior proceedings were still in existence, that does not change the failure of the English court under Article 19.3.
Well, it depends on whether it's a new point. That's what I'm trying to identify first. Because you see, if you go back to page 283, paragraph 60A, the application being made was again on the basis to declare that the Court of Turin remains first seized. That was the case being made at page 246. That was the case being made at page 283. Is your case now a new case?
Well, my lord, with respect, if your lordships take the view that that was a wrong submission for the husband to be making at that stage...
I'm not taking any view. I'm
No,
just
no,
trying
but-
to identify what the case was. That's all.
But even if your lordships were to take the view that that was a wrong submission, it would not change the responsibility of the English court, in this case Her Honour Judge Roberts, to apply the spirit as well as the letter of the Rogers-Heddy-Carr case, which is in the bundle of authorities and I'll come back to, but that is the case which in a nutshell says it doesn't matter what jurisdiction is pleaded, what matters is the court's responsibility independently to look at its jurisdiction and make the orders that it is able and indeed required to make.
But the reason that it matters is because courts don't, although sometimes courts act on their own motion, the usual position is that courts act when they're asked by parties to do something.
My lord, I entirely accept that that is the way traditionally that the English court has
Or we
operated.
have an adversarial system.
Entirely accepted.
You can have shall in a directive, but the parties may agree something else. So the point never arises because the parties have agreed on a different course of action. So English courts tend to act if they're asked to do something, which is, I think, why my lords are interested in seeing when it was that this point was first formulated.
My lord, yes, save that, of course, the English parties to English litigation cannot invest the English court with a priority jurisdiction in relation to...
No, but we've already established the English court had jurisdiction. The question is when and how, if at all, it came to an end. That's why the point about you saying not beyond that point when Article 9 required the English court to dismiss the petition, that's your case. And that's why we're exploring when that, when the parties, or in this case when the husband, asked for that to happen.
My lord, yes, and forgive me, my only point in answer on the parties' agreement aspect is that the parties could not themselves prolong the jurisdiction of the English court by agreement.
Well, there may be a point about that, but at the moment we haven't established precisely when it is the jurisdiction came. I mean, we've got your formulation, but as a matter of fact, when that might have been.
You were on paragraph 50 on page 246. That's where you got to on your journey back in time.
Lord, thank you.
And my lord took you back to 283 and reminded you that the word there was remains. The court of Turin, that was the point where it's been argued. And that's obviously the way it was also argued here, paragraph 50 on page 246 before Judge Everell. Paragraph 50, read as a whole, is the assertion that the court in Turin remains seized.
My lord, indeed, and your lordship sees the alternative formulation in paragraph 51, the successor paragraph that goes then into the justy paragraph.
But that, I mean, it wasn't argued at this stage. It wasn't being argued in the way you're arguing it now, because paragraph 51 is on the basis that the court has a discretion or power to decline to dismiss the petition. But that's not how you're putting it now. You're saying it didn't.
Well, my lord, with respect, however it was formulated to His Honour Judge Everell, and I appreciate this is not an appeal from any order of His Honour Judge Everell.
No.
Indeed,
yes.
One of the curiosities is that there isn't an order from His Honour Judge Everell. But it is a matter that was squarely put before Her Honour Judge Roberts in the November hearing. And we have looked both at the skeleton argument and at the closing submissions. And my Lord, Lord Justice Baker has already observed rightly, if I may say so with respect, that one of the factors, one of the aspects of the case that Her Honour Judge Roberts expressed as unsatisfactory was that she didn't get to hear closing submissions from the parties' advocates because, yet again, the time estimate was so inadequate. One has, if I may say so, with respect as well as sympathy for Her Honour Judge Roberts, and she is, of course, DFJ and highly respected, rightly so, for her work, particularly most recently at the CFC. But nevertheless, it is absolutely clear from her judgment that in a number of separate respects, the case that was presented to her and the manner in which that case arrived on her desk was deeply unsatisfactory to Her Honour Judge Roberts, and she was doing her best in what was clearly a situation that was very seriously suboptimal.
Okay.
She sets out 6 respects.
So,
Like judges up and down the country every day of the week.
My Lord, I entirely
I'm afraid, certainly over the last 2 years. I mean, this may be a particularly egregious example, but I would say that that is a position that judges have found themselves in, doing their best in, as you put it, suboptimal conditions.
And my Lord, I entirely accept that with respect, but the effect of the 6 separate respects that Her Honour Judge Roberts sets out taken with the scant treatment of this central point in my submission, is a further reason why this court should accede to the husband's ground one.
Right. Okay. So can we go back to we've got to page 246. So going back in time, where do we go?
If I could invite you then to go to, forgive me, on the paper version, 120, please.
And this is what document?
No, I'm sorry, I've given you the wrong page reference, forgive me. Paper.
Is this part of the transcript before the judge?
I'm so sorry, if you can.
If it's the transcript before the judge, we've got internal pages.
Yes, thank you. It will be 114, paper 114, which is internal page 40.
Yep.
And this is, as your lordships see, an exchange between my learned junior, Mr. Lazarus, for the husband, and His Honour Judge Everett, in which at the top of the page...
This is when?
This...
2nd of December 2019, I think. Bundle, page 75, is that the first page of this?
My lord, it is.
Right. So which exchange?
On paper 114, top of the page, Mr. Lazarus, if the Italian court did, then it would be necessary to apply to lift the stay and dismiss the petition. And...
Or did or didn't what?
Forgive me.
Okay, seized jurisdiction. I
Yes.
see. Yep.
The
Okay.
operative bit is the previous page by the second hole punch under the heading Judge Everett,
Yes.
when the learned judge says, but the English courts don't, as it were, do anything unless somebody prompts the court to do so. Picking up on my Lord Justice Coulson's observation a moment ago. So it needed somebody to apply to lift the stay and ask for the petition to be dismissed under Article 19.3. If the Italian court has not established jurisdiction, then there needed to be some further direction. That's how it seems to me, subject to reflecting overnight. And so the exchange, which I invite your lordships to consider, is on page, internal page 40, paper page 114 of our supplemental bundle. And the passage, it's just by the second hole punch, where there is a section, Judge Everett, no, I can see you could read it saying, well, in fact, I don't need to lift the stay to apply to dismiss the petition.
Sorry, wait a minute. Where are you?
I'm on paper page 114.
Okay, yes, got it. Yes.
By the second hole punch. I'm assuming it is by the second hole punch, forgive me. It looks as if it should be. Judge Everett, no, I can see you could read it saying, well, in fact, I don't need to lift the stay to apply to dismiss the petition. Just apply to dismiss the petition, and it would probably be done by consent. And then Mr. Lazarus says, well, the English court should have declined jurisdiction because Article 19.3 requires it. And Judge Everett says, yes. Now, I'm not...
And Mr. Lazarus then says, but that doesn't lead to an automatic dismissal of the petition.
My Lord, yes, I entirely accept that, and I'm not trying to set up a judicial or other estoppel. But I am suggesting with respect that this issue was absolutely centrally before the court.
Well, that goes, I mean, we're island hopping here in the worst way, but this comes right at the end of 40 pages of debate about other material. And then this point arises, there seems to be a debate as to who gets the last word. Miss Jackson makes a couple of final points, and then Mr. Lazarus makes this point, and it's difficult to say it's then central, isn't it?
Well, my Lord, I would invite your lordship to say that because of the repetition, it is very much centre stage. And if I could invite your lordships in the same transcript, so December 19, still Judge Everall, back to paper page 101 in our supplemental bundle, it's internal page 27 of the transcript. Where, again, at about the same passage, it's 2/3, 3/4 of the way down the page, same point in relation to the second hole punch. Judge Everall says, yes, and you can see why the Deputy District Judge worded her order in that way and included paragraph 6, because presumably it was thought that by the 11th of August that the Italian court would have either said, yes, we've got jurisdiction, or no, we don't have jurisdiction. That's why it was listed for a mention to consider the dismissal of the English petition, because it was assumed the Italian court would say, we've got jurisdiction, and under 19.3 the English court would have dismissed the English petition. And so, again, I do say with respect that, yes, there isn't a piece of paper.
This is the judge.
Yes.
As part of this sort of Oxbridge Debating Society. I mean, you know, these are all exchanges with the judge, which I don't think led to any order. I completely understand the point of law that arises, but I'm about to say at the moment, the fact that the judge is having this well on the one hand, well on the other hand sort of debate, possibly with himself, doesn't seem to me to make very much difference.
Lord, I entirely accept the force, of course, of your lordship's observation. I will not weary the court with further reference, apart from just of this final point, which your lordship, my lord and Lord Justice Coulson, may think emphasises the point that your lordship has just made. Paper 86, transcript again. It's now page 12 of the transcript, and this is internal page 12 of the transcript, halfway down. Sorry, by the first hole punch. Judge Everall, well, no, because there's a distinction between, I mean, if you look at Article 19.3, where the jurisdiction of a first court is established, the court's second sees shall decline jurisdiction. And then Mr. Lazarus says yes, and that's what should have happened in this case. Unfortunately, for reasons that nobody amongst the lawyers in this room can explain, instead of the parties actually seeking dismissal of the petition remains, stayed. And the Lords...
I certainly have sympathy with Mr. Lazarus's submission. I'm starting to get close to tendering final submissions, which I would much rather develop in a more regulated manner by reference to authority. I have, in the light of my earlier comment, I have considerable sympathy with that.
Well, my Lord, I'm sure that my learned junior hears that with considerable thanks, quite apart from comfort and consolation.
I don't think anybody was able to make a submission of more than about 2 sentences, as far as I can see. Anyway, there it is.
My Lord, perhaps the less I say about that, the better. But I entirely see the force of your Lordship's observation. All of this, with respect, my Lords, comes down to the central spirit, and I'm going to call it the injunction, that Lord Justice Thorpe issued to all of the English legal profession in the case of Vermouth 20 years ago. It's the case passage quoted by my Lord Justice Moylan in the E&E case. And it's the passage about espousing the European regulations. If I could invite your Lordship's attention to the authorities bundle. It is at page 21. in the bundle, which is the case report of E against E in front of my Lord Justice Moylan at first instance. That is the case that starts in our bundle at page 13 and is a case that looks specifically at the French case of A against B, which my Lord Justice Baker referred to earlier. That case of A against B, the French judicial separation case, is different case from the one that my Lord Justice Baker was looking at in the judgment in this case that my Lord Justice Baker referred to in your judgment 3 years ago. So I distinguish between, on the one hand, the maintenance case called A and B, which really isn't of any relevance to this case today, and on the other hand, the French judicial separation case of A against B, for which it's right that I must declare an interest because I was counsel in that case, both in England and...
So we've read, you wanted us to read the passage in that I quoted, paragraph 43. Is that all you want us to look at in E&E at the moment?
My Lord, yes, but it's particularly what I referred to as Lord Justice Thorpe's injunction at your Lordship's paragraph 43
Yes.
in the E&E report, espousing Brussels II and apply it wholeheartedly.
This is an issue of law. There's a right answer and a wrong answer. That's all.
My Lord, yes, but it's, as your Lordship will appreciate, it's the reference to usurping the function of the judge in the other member state by rely on as well.
Okay. Yes.
My Lord, the mention of my Lord Justice Baker's judgment from 2018 is perhaps a convenient moment to raise the separate application, the preliminary application to today's appeal, relating to the unagreed bundle, the unagreed document, particularly being a skeleton argument from January 2018, settled on behalf of the husband by Stuart Leach, Queen's Counsel, and Judy O'Malley. That was a skeleton argument which I believe I'm right in saying came before my Lord Justice Baker in the context of that case in 2018.
Was this before the judge below?
I think the answer is no. May I have just a moment to check, please?
If it was, we should. Yes.
My Lord, it goes to...
Was it before the judge below?
I'm sorry. No. But it goes to the centrality of the Article 19.3 point and the wife's awareness of its consequence. Because I appreciate that it will be said on behalf of Dr. De Filippo that she was, for long passages, acting in person or with direct actors counsel. So it is...
Sorry, I'd rather overlooked that. So you're making an application that those submissions should be adduced before us, or we should look at them.
My Lord, it's more simple than that, if I can put it that way.
Right.
There is one passage, one paragraph, which establishes as a historical and chronological point the centrality of the Article 19.3 point at an early stage.
Right, thank you.
And gives the analysis of why it is irrefutable at that stage in any event, because the...
Mr. McGee, what submissions do you want to make on this?
My Lord, taking it first of all that was not before Judge Roberts in the lower court, and the court is concerned with the question as to whether Judge Roberts fell into error, cannot have been if this wasn't before her. And in terms of the document itself, it pertained to wholly different proceedings. And I'm not quite clear what it is suggested my client did or did not understand. Whether she was representing herself or through direct access counsel, it's not suggested that at no time did she understand the position of law because of her status as litigant in person. As the court has already been referred to, my client early on had instructed international experts on the issue. And so this document that pertains to different proceedings, separate proceedings concerning the parties, is not relevant, because at no time does my client advance the defence, if it is such a defence, to say, I didn't understand that that was the position in law.
Right, thank you. Mr. Amos, anything in response? Just about whether or not we should look at this?
Yes, my Lord, its relevance to the wife's position when she is saying to your lordships, I didn't know. And it's the same point as your lordships looked at in relation to that chronology of the wife herself. The one I got the wrong year for, it should be 17th of June 2017, where she said, we knew that it was likely to lead to a stay, but we nevertheless went ahead and issued our second petition in England.
Thank you. We're just going to rise for 2 minutes.
Just be advised, streaming is on, if you would like to discuss anything, then you're more than welcome.
Mr. Amos, we're going to refuse that application. It wasn't before the judge below, and we don't think we should look at it in those circumstances.
Lord Soviet. Can I move on to a different submission, please, which is to look at the position relative to Article 19.3 in two separate stages, chronologically. I accept, of course, that Her Honour Judge Roberts was looking at the position in November 2020. But I invite this court to consider briefly what would have been the position if she had been looking at the position before the 7th of October 2019, which is the date on her finding that the judicial separation proceedings in Italy concluded. In my submission, if she had been looking at the position before the 7th of October 2019, then the answer is entirely clear, incontrovertibly clear. She would have been required to dismiss the petition under Article 19.3. And that must be so, in my submission, whether or not there is a piece of paper before the court to that effect.
How is that going to happen? I mean, it's just a matter of interest. It didn't happen. Somebody in the court is going to pick up the file, say, oh look, here's a undismissed petition, which Article 19 requires us to dismiss, absent any application. How's it going to happen?
I'm sorry, it's my fault. I should have added one further sentence. I apologise. If Her Honour Judge Roberts was hearing the case before the 7th of October, face-to-face or remote,
yes,
but nevertheless...
and an application hadn't been made to dismiss? So is that predicated on that basis, or that an application to dismiss had been made?
My Lord, on either basis, if she, Her Honour Judge Roberts, on this scenario is aware that there are competitor proceedings that are prior in time in Italy, she was required to dismiss actively.
Even if nobody was asking for that?
Well, my Lord, the answer to that is yes, but with respect, as I have sought to demonstrate at any event, somebody was asking for it loudly and repetitively.
No, that muddles together the two completely different points. That's why my Lord asked you, on what basis? So she's hearing the case, and there are two different scenarios. One is she's asked to consider the point, and one is she isn't. Do you say the answer is the same, whichever?
My Lord, I do, but I absolutely accept your Lordship's implication that you have to treat those two questions separately. And so my answer is yes, you have to dismiss whether or not there's an application. But if I'm wrong about that, then at the very least, you have to dismiss when somebody is advertising to the court for not speculative grounds, but demonstrating to the court that there is a competitor set of proceedings that is entitled to priority and activates, engages Article 19.3 that requires the English court to dismiss its own process.
You know, we can't impose on hard-pressed judges dealing with these cases an expectation or obligation to look at these matters if they're not being raised before them. Can we?
Well, my Lord, with respect, yes, where it is this fundamental, in other words, Article 19.3, the mandatory and active requirement.
Well, don't forget, as I said before, divorce is now completely digitised. The first process in the reform programme to be completely digitised. Who's going to look at this act proactively if nobody raises it on an undefended and a divorce that just goes through?
My Lord, I entirely accept that there will be inevitably cases of complete ignorance. But with respect, this case is not going to be one of them, because this case had the flashing light. So even if nobody had said anything in my submission, what you have seen from the transcript with His Honour Judge Everall, for example, shows the judicial thinking that Article 19.3 is mandatory and I will have to apply it if it is appropriate. By appropriate, I mean if the circumstances are met, then I will have to apply Article 19.3. And so even more with respect, in circumstances in relation to the judge below, namely Her Honour Judge Roberts, where she is being positively requested by the submissions made on behalf of the husband to exercise Article 19.3, because otherwise, if I'm wrong about that with respect, then Article 19.3 becomes optional rather than mandatory.
I think we're going some way from this case, but there could be all sorts of reasons why Article 19.3 does not apply in a case. So you need to establish the framework, factual framework, the legal framework, and then whether Article 19.3 does or doesn't apply. So you need several established facts. And in your analysis, the court somehow is going to know that there is another jurisdiction in which there are proceedings, which has accepted jurisdiction, which is accepted, which isn't being appealed, which isn't being challenged. So this is why I think we're questioning, and I think we're going some way away from this case, and it's probably necessary, questioning this idea that the court leaps into action without anybody suggesting that it would be appropriate for it to do so of its own motion because certain facts appear to be established or accepted.
But, my Lord, with respect, by the time the case reaches Her Honour Judge Roberts, and by the time Her Honour Judge Roberts is giving her judgment, those facts are already established.
Well, what facts? You see, that's why we were looking at remains seized. One of the issues she was being required to determine was there one continuous set of proceedings in Italy, judicial separation and divorce, which were effectively the same set of proceedings?
Yes.
Now, until that was determined, she didn't know whether Article 19.3 might or might not apply at all. Then she had to look at the dates of those respective proceedings and decide when one came to an end, what was the consequence of that coming to an end, did Article 19.3 apply in those circumstances?
But, my Lord, with respect, it follows that she decided, Her Honour Judge Roberts decided that the JS proceedings in Italy came to an end and the date's 7th of October. So,
Yes.
whatever view the learned judge took of the situation thereafter, it was not open to doubt, in my submission, that prior to that date of the 7th of October, there had been a situation of lis pendens where the English court was second in time, where it had been obliged under 19.1 to stay its proceedings until the court first seized had established its jurisdiction, which the Italian court did at the latest by the order that we referred to earlier, namely the May 2017 order, 18th of May, and I can take your lordships to it if that would assist.
Right, okay.
And that's why I invite your lordships, if I may, to think of the case and of Her Honour Judge Roberts' treatment of it in the two steps. If, counterfactually, she'd been dealing with the case before the 7th of October 2019, she would have been obliged to dismiss the English petition. And if I'm wrong about, well, she would have been obliged to notice it for herself and dismiss it. She would certainly have been obliged when the husband's counsel was saying to her, in my submission, loud and clear, there is a set of proceedings in Italy which has been going on and has always been prior to the English divorce proceedings, and which this court should at all times since 2016 have dismissed.
The dates have slid about a bit. Your formulation where you accepted there was jurisdiction, the English court would have jurisdiction, but not beyond the point that Article 19 required it to dismiss the petition. When precisely did you say that was?
My Lord, it was when the Italian court's jurisdiction was established, and at the latest I say that was 18th of May 2017.
2017.
2017, yes.
Right, okay.
And forgive me, when I said a moment ago, I quoted the submission made by Moylan Jr. to Her Honour Judge Roberts. It was saying this court should have dismissed it since 2016. That's where the 2016 reference comes in, and I'm sorry if I confused the matter by referring to that without specifically
But your case is
identifying it.
When the Italian courts established jurisdiction, you say 18th of May 2017.
At the latest, yes.
Yes, right. So by the time it came to Judge Roberts, 3 years down the line, so on this basis, what is the position in relation to that 3 years worth of activity? Is it all a nullity?
Well, my Lord, in relation to the status of the English divorce petition, in my submission, yes.
Because I mean, that must mean, mustn't it, that all of the debate to and fro in front of Judge Everall was all nothing to the point, because you say the English court didn't have the jurisdiction.
My Lord, yes.
I mean, it just sounds rather counterintuitive that you can have 3 years worth of litigation and then turn around and say, well, actually, it's all a nullity because the English court didn't have jurisdiction by reference to something that didn't happen but should have happened on your case.
But, my Lord, with respect, if one deploys the same argumentation on the flip side, it is saying, well, although 19.3 required the English court at all times up to the 7th of October 2019, required the court mandatorily to dismiss its proceedings and actively to dismiss its proceedings, notwithstanding that mandatory requirement, we didn't do what we were required to do, and now...
And everybody was very happy with that, and everybody got on with it.
Well, with respect, I would challenge the proposition that...
Well, we've seen the transcripts a bit there 2 years after your date, December 2019. Anyway, you say all those proceedings were a nullity because, as from the 18th of May 2017, the English courts didn't have jurisdiction in respect of the divorce.
My Lord, yes. And therefore, with respect, whether or not the parties were happy to go on debating it does not affect the result. Because I entirely accept your Lordship's characterisation that the parties went on debating it, apparently, whether happily or otherwise, but nevertheless went on debating it at length in front of His Honour Judge Everall.
Well, I mean, that would potentially raise all manner of questions of ad hoc jurisdiction, estoppel, variety of points. But at all events, your case is no, that the proceedings are annulled because the English courts did not have jurisdiction after 18th May.
Lord, yes.
Yes, thank you.
And so, remaining, if I may, with the two-stage approach, I invited the court to look at the position if Her Honour Judge Roberts had been looking at it pre 7th of October 2019, and invite your lordships to say, well, clearly there would have to have been a dismissal because of Article 19.3 up to that point, and then to ask the question secondly, what difference, is there any difference in fact after the 7th of October 2019? And of course I accept that Her Honour Judge Roberts's finding was that 7th of October 2019 brought the Italian proceedings to an end. And therefore, on her finding, thereafter there was no continuing competitor proceedings. But if I invite your lordships to say, if in fact the position pre 7th of October 2019 was that the English petition should have been dismissed, then it cannot be right to say, well, because in fact it wasn't dismissed, it now suddenly acquires priority. And in advancing that proposition, I rely on the case of E against E, my Lord Justice Moylan's case at first instance, and in particular the analysis that my Lord, your Lordship gave in that case in relation to the A and B French judicial separation.
Might it be then helpful if we go to A and B first, and see what A and B says before we then go to
By
E?
all means, yes.
Because that's the chronological.
Of course, it's in the authorities bundle at paper 3, page 3.
And in that case, if I could just, the husband started effectively divorce proceedings in France. The wife issued a petition which was dismissed. She then issued a second petition prior to the determination of the then existing proceedings in France.
My Lord, it may not matter. I interrupt only because, as I said earlier, I should declare the interest that I was counsel for Mrs. A in that case, both for the reference and for the European Court decision. So it was that the husband had started separation proceedings rather than divorce.
I know. They were a precursor to divorce proceedings. They were non-conciliation or conciliation proceedings.
But with respect, they had this distinguishing feature, which
Yes.
was that they were proceedings which expired through reflection of time 30 months after a particular court
Yes.
hearing in France.
But up until then, they were continuing.
Exactly so.
Yes.
Yes, forgive me.
And
Yes.
the point I was seeking to draw from the head note is the wife's English petition was issued prior to the effluxion through time of the French proceedings.
Indeed.
So when she issued her English proceedings, there were two extant proceedings, one in France, one in England.
My Lord, that's right.
And in the French proceedings, the jurisdiction had been established.
My Lord, yes.
Because it must have been established because the English court dismissed the
Yes.
first petition on that very ground.
Yes. So the English court, with respect, did what it should have done in accordance with Article 19.3, dismissed the English petition.
So applying that sequence of events to your submission, the English petition that was issued during the currency of the French proceedings should have been dismissed, but wasn't, but was still a nullity.
Well, my lord, with respect, that's not what the European Court found.
No, I know, but I'm applying your submissions to the facts of this case first.
I'm so sorry.
Before we go and look at what the European Court decided. I'm just saying, speaking for myself, your submission appears to me to be, if proceedings are started in State A during the currency of proceedings in State B, which has established its jurisdiction, the proceedings in State A become a nullity from the date in which the court in State A has established its jurisdiction.
My lord, yes. And the distinction, if I may say so, is the nature of the proceedings. And in the A against B French JS case, it was proceedings that expired. And that is the word...
The nature of the proceedings. The proceedings are JS proceedings, as they were here in Italy. You mean it's... Well, what do you mean? You were saying it's because they expired.
My lord, I'm rightly corrected, and I should be more precise. The procedural nature of the French JS proceedings in the A and B case was that they were time limited.
Sorry, can you explain what you mean by that?
Yes, that they expired by operation of law.
Yes.
30 months after the ONC, the Order of Non-Conciliation.
But how does that impact on what the effect of the existence of those proceedings on the application of Article 19.3 to the second in time proceedings?
Well, my lord, if I may, I'm going to answer that by reference to your lordship's judgment in E&E.
Well, no, I would like to see how it's dealt with in A against B. Because at the moment, again, speaking for myself, I see A and B as being contrary to your submissions. Because the factual situation was the same. Proceedings in existence, jurisdiction established in France. Prior to the determination of those proceedings, petition issued in England, the European Court decided that once the JS came to an end, the English proceedings being the only extant proceedings became first in time. And on your argument, the European Court should have decided they were a nullity, because the English court should have dismissed them, indeed without any application being made. But that's an aside. So you have to, in my view, at least show why the determination in A and B does not apply to the facts of this case. And what you've said at the moment is the difference is that in our case, this case, the proceedings came to an end by order, and in the French case, they came to an end by effluxion of time because the order expired at midnight on the 16th of June 2014.
My lord, I appreciate that my point won't improve with repetition, but the distinction remains in what I have referred to as the time-limited nature of the French separation proceedings in that case.
How does that, as a matter of principle or as a matter of law, impact on the application of Article 19?
It does, my lord, in this way, that looking at the way that the court, the European court, dealt with the case of A and B.
Yes.
It was specifically looking at a situation, and I'm looking at the head note at number 1 on page 3 of the bundle of authorities.
Yes.
I'll then take your lordships, if I may, to the judgment. But it's looking specifically at in a situation such as that at issue in the main proceedings, in which the proceedings before the court first seized in the first member state expired after the second court in the second member state was seized. And it's for that reason that I also rely upon what your lordship, my Lord Justice Moylan, said in the E&E case about the essential non-applicability of the A against B case to this debate.
So you're saying that A and B applies if somehow the proceedings have expired, but not if they have been determined by some other means.
My Lord, correct. I am saying that A and B, as a principle, applies to expiry cases.
And is there anything in the
Expiry
text
procedure.
of the judgment of the court that would support that interpretation of its decision that you want to take us to?
Well, if, please, I could invite your lordship's attention to page 35 of the report, which is in our bundle, page 7. The relevant article of the French Code is set out at the top of the page in the second paragraph. In the event of reconciliation, the spouses or the proceedings for a decree of divorce have not been instituted within 30 months. So that's the time-limited point. And then the chronology is set out relevant to that case. And in particular, paragraph 18, your lordship see the referring court, which was Mr. Justice Mostyn in the High Court in London, explained that no petition or assignation having been filed within the period of 30 months from the making of the non-conciliation order by the French court, the provisions of that order expired at midnight, as your lordship said a moment ago.
Yes.
And we then have the chronology of what happened thereafter, as your lordship has already recorded. It's on page 8 of our bundle, paragraphs 20 and 21.
Yes.
And paragraph 24. And under the heading on page 9 of the bundle, consideration of the questions referred at paragraph 26. Again, with respect, I say that consonant with the head note, this court decision, A against B, is dealing with proceedings such as that in issue in the main proceedings. I'm looking at the 5th line of paragraph 26, in which the proceedings before the court first seized in the first member state expired. So again, it is the time-limited nature of the proceedings, I invite you to say, that marks the importance of A against B. And then going forward, please, if you would be so kind, to page 11 of the bundle and paragraph 37 of the judgment of the European Court. However, in order for there to be a situation of lis pendens, it's important that the proceeding is brought between the same parties and relating to petitions for divorce, judicial separation, or marriage annulment be pending simultaneously before the courts of different member states. Where two sets of proceedings have been brought before the courts of different member states and one set of proceedings expires, the risk of irreconcilable decisions and thereby the situation of lis pendens within the meaning of Article 19 disappears.
So one has to interpolate into that, where one set of proceedings expires, by what? By an order ceasing to have effect? Because
by a function of time, I would.
Because, I mean, I would be interested to know what the word is in French. Because actually the word expires doesn't appear in the French provision, does it? It just says that if you haven't institute divorce proceedings within 30 months, so the provisions are null and void. So the proceeding has come to an end. They don't say expire. So it's not a term of art.
It's the French word caduc, and I suspect that your lordships are not going to be assisted by a debate, particularly a one-sided debate from the bar about that.
Right. Okay, but you say expires means by fluxion of time, not in any other way.
My lord, I do. And going on to paragraph 42, I say with respect that that submission is fortified by what appears at paragraph 42, namely, accordingly, in a situation such as that described in paragraph 40 of the present judgment, in which the judicial separation proceedings before the French court lapse as a result of the expiry of legal time limits. Yes.
So that's lapse. Different word.
The criteria for lis pendens, I'm sorry, I've lost the reference. The criteria for lis pendens are no longer fulfilled as from the date of that lapse,
Okay.
and the jurisdiction of that court must therefore be regarded as not being established. And similarly, in paragraph 45, again, it's the word expired that appears at the end of line 6 in the court's judgment.
But so the fact is, when the second proceedings were issued, there were proceedings pending simultaneously before the courts of different states.
That is true, and that was the point that was advanced to your lordship in the case of E against E.
And there's nothing in this decision which says that the second set of proceedings issued whilst there are pending proceedings in another member state are void a nullity.
There is nothing, as your lordship says.
And if, right, okay, yep, thank you.
And so, with respect, I invite the court
To E and E?
to E and E,
Yes.
and the particular paragraph is 39 on bundle page 20, which is the internal page 665 of the report.
Okay, can we just look at the head note to get the,
My lord,
so we're
certainly.
absolutely clear about the factual basis?
Yeah.
May I just?
Yeah.
That's at page 13 of the bundle.
Initiated divorce fees in France, 2011. Thank you.
My lords, I promised your lordships earlier to come back to the word actively.
39, are you taking us to, did you say?
39, yes.
Thank you.
And that picks up on head note point 3.
Yes. Well, and yes. And head note point 2.
And indeed head note point 2. But it's the actively dismiss that I wanted to make good on. Paragraph 39, and forgive me, I should start at 38, obviously. Where your lordship said, Mrs. Bailey Harris submits that this case fundamentally impacts on the application of Article 19, so this case being A against B, the French JS case that we've just looked at, and specifically the meaning of the word decline. And my Lord Justice Moylan said, I respectfully disagree. All that A and B decides, in my view, is 1, that the issue of when a court is seized is not affected by Article 19, or by the existence of other proceedings in another member state at the date or time of the court being seized. And 2,
Sorry. Yes.
No, my lord, I'm
No.
anticipating a question. I don't
No.
want to interrupt your
No.
lordship's train of thought.
No. No, don't worry. That.
Right, and 2, that if proceedings before a court first seized expire after another court is seized, the criteria for lis pendens are no longer fulfilled. And then I will also invite your lordships to go on to look at paragraph 40, but I don't want to get ahead of myself.
No, well, why should we read that now? 40.
Your lordship went on to say, I fail to see how the court's determination in A against B has any effect on the application of Article 19 in the present case, or on the meaning of decline. In the course of its judgment, the court states in paragraph 35, where that jurisdiction of the court first seized is deemed to be established under the rules in Article 3, and I would interpolate there at the latest, in this case, 18th of May 2017, the court second seized is to decline jurisdiction in favour of the court first seized, in accordance with Article 19.3 of that regulation.
But I would draw your attention to what I said in 39.1, that A and B decided that the issue of when a court is seized is not affected by Article 19, or by the existence of other proceedings in another member state. So that also might seem to be contrary to your submission, that the effect of Article 19 is to render proceedings seized in State 2 are a nullity.
Well, my lord, with respect, I can see the force, obviously, of your lordship's observation about that, but it does not, in my submission, take away from the fundamental point that the English court in the present case, Manetta and Filippo, failed in its duty under 19.3, and that when Her Honour Judge Roberts was considering what to do with the case, what to do with this case, it behoved her, at the very least with respect, to do more than say as she did in relation to Mr. Lazarus's submission about dismissing the petition. At page 58 in the core bundle,
Yes.
where in the judgment, Her Honour Judge Roberts said this, it's the second paragraph of the page, internal page 15 in our core bundle, page 58. The central issue is, as I've said, which court, Italy or England, is first seized of the parties' divorce proceedings for the purpose of Article 19. And then this, there is a consensus between counsel as to the issues I need to decide to be able to determine this question. So logically prior, she said, in my submission, rightly, is should I dismiss Dr. De Filippo's, so that's the wife's petition, as Mr. Manetta, the husband, submits because it should have been dismissed pursuant to Article 19. And she then says, I shall take this quite briefly.
Yes. Thank you. So is that E and E?
My lord, that is E&E with the addition of the passage that I referred to earlier. If your lordships would go through to page 21 of our authorities bundle, it is internal page 666 of the report and paragraphs 42 and 43. 43 particularly quoting what I referred
Yes.
to as Lord Justice Thorpe's injunction.
Right, thank you. Next authority?
I shall come on, if I may, to Rogers and Hedicar, but with this preliminary point, which picks up between E&E and Rogers Hedicar. my Lord Justice Moylan's point in the E&E case, and I say this obviously with some diffidence in the presence of Lord Justice Moylan, but in my submission at any rate, what comes through the report very strongly is that the English court should actively discourage tactical filing of second petitions. That is, of course, exactly what happened in the present case, a tactical filing, as your lordships have seen in relation to Dr. De Filippo's chronology dated 17th of June 2017.
Was there any determination below that it was a tactical filing? Was that raised as an issue? There wasn't oral evidence, was there?
My Lord, no, there wasn't. There was consideration exactly of this point because there are 3 references, if I may, which I'll take your lordships to on this point.
Well, 3 references where?
In our bundle.
No, but did the judge decide, was she asked to decide that it was a tactical filing? Was it an issue below? You can't just suddenly make a submission that it was a tactical filing if the judge was not asked to and did not make any determination below as to whether it was or wasn't. And given that she didn't hear, did she hear oral evidence from the parties?
She did not hear oral evidence.
I would have thought it was difficult for her to have done so.
But what she did say in the judgment was that on the wife's case, she either didn't know or maybe didn't know about the Italian proceedings.
Well, and also, the
yes.
jurisdiction was in dispute, might have been in dispute, until May 2017. What was the date of the petition? 2016.
Yes.
So, it's... you just can't make a submission that it was a tactical filing absent a finding to that effect, I'm afraid. Doesn't matter what you refer to as to in the documents, we can't make a finding that it was a tactical filing.
Lord, may I have just a moment? Please?
Yes.
Just to check one reference. My Lord, the only finding that appears in the judgment is that, and it's in the core bundle at 46,
Yes.
is that on the wife's case, it's in the, just above the first hole punch.
Yes. On
On
her
the
case,
19th
she was unaware. Is
Being
that-
unaware on her case.
Yes.
And
And the judge didn't deal with that.
didn't deal with that.
But I think a fortiori, it's difficult for you to make a submission that it was a tactical filing when the judge below hasn't resolved whether she was or wasn't unaware, but her case was she was unaware.
But, my Lord, in circumstances where I can show, and have shown this morning, that the wife accepted in that chronology that she was aware and therefore filed, notwithstanding that she knew that the English petition...
In any event, my Lord's warnings about tactical advantage are addressed, if you look at paragraph 41. The court should not encourage and should actively discourage the tactical filing of a second set of proceedings in England when the jurisdiction of the court or another member state has been established. In this case, the petition was filed, divorce petition was filed in this country before the jurisdiction in Italy had been established. That's why the jurisdiction, the order was stayed, the petition was stayed originally.
Well, my lord, that I must accept, do accept.
So
I think time is going by, so I think we need to move on because it's almost 1 o'clock.
Yep,
Yeah. I know we started late, but
no, I'm very happy to move on.
So I don't think the tactical point, for my part, the tactical point isn't a.
so you're going to take it. Is Roger's header car not better reported?
My lord, I know it's not in the family law reports.
Right, but
Which has
the
always
original,
struck me as odd, but
because this is terribly small font. Can you tell us which paragraph you want us to read, please?
yes, well, the first is I do apologise for
No, what I'm proposing is you tell us the paragraphs, we'll then adjourn, and we'll get bigger font, because we can get the original font within the Court of Appeal judgment. So which paragraphs?
My lord, the key is paragraph 13.
1-3.
Yep.
Okay, thank you. We've asked you an awful lot of questions, so it's our responsibility that we are time-wise where we are. How much longer do you think your submissions will be?
My lord, I anticipate 20 minutes.
Thank you. Right, we'll adjourn now and start again at 2 o'clock.
What time?